I think it's somewhat ironic that one of the more active northern sites during the civil rights movement in the 50s and 60s was the relatively progressive community of Yellow Springs. I say relative because it was just that. I mean, you know, there were certainly problems here, and Yellow Springs was a microcosm of segregated U.S. at that time. But there were several sort of bright spots. There were a number of blacks who were involved in governmental positions in town. People served in many capacities, police chief, mayor, what have you. So it was and the other thing is that in terms of being a relatively progressive community, it was really the focal point of the House Un-American Activities Committee for a number of years, for being a hotbed of communism. Well, so in any case, I think it's sort of ironic that it turned out that there was a riot here. It's sort of in this context that after the Second World War, a number of blacks, Negroes as they were called at that time, in the community started some activities to improve the status of blacks in the community. The Miami Township Committee for Fair Practices was one of the outgrowths of those activities. It was during this period the village of Yellow Springs adopted an anti-discrimination ordinance. Result of that activity and the Miami Township Committee for Fair Practices, most of the restaurants, the theater, other places in town were integrated over a period of a few years without a great deal of difficulty, but with a lot of work. One of the sort of holdouts during this period in town were the barbershops. They were sort of the last place to integrate. One of the, and the major holdout, the most reluctant barber in town was Louis Gegner. That's the reason why he became sort of the focal point of the efforts over a period of 4 or 5 years. One of the, I think the sort of initial legal cases revolving around the barbershop was a result of a complaint filed by Phil Adams. This was under the new, relatively new anti-discrimination ordinance in Yellow Springs. That particular case, which involved a number of people, some of whom were here. Harold Cordell was one of the witnesses during that case. Resulted in a legal case in Greene County, even though it was under a Yellow Springs ordinance, because the ordinance did involve, did use as some of the measures of, settling cases, fines and sentence, jail sentence. The hearing took place in Greene County Court. This was involved it was a jury case, and over a period of a couple of days of hearing, the jury unanimously found Louis Gegner guilty of discrimination, which was quite unusual in Xenia, Ohio at that time. That was sort of the starting point also for a number of Antioch connections in terms of activities in this area. One of the witnesses for Phil Adams in his case was Al Stewart, who was a physics professor at Antioch at the time. Even though Gegner was found guilty, in this particular instance. It was not until 1 year later that he was fined $1 for his anti-discrimination practices. One very interesting sort of side issue that occurred during this case was, Gegner had indicated that the reason he did not serve blacks was that he did not know how to cut their hair. One of the witnesses in the case was an Antioch student, Dave Epstein, who had very curly hair. And Gegner had cut his hair at least a couple of times without any problems. That was probably one of the more decisive things that helped to settle the case. Gegner's attorney at that time was Harry Kyle, and I think he may have been appointed by the court, but I'm not sure. But in any case, Harry Kyle ended up representing Gegner throughout all of the subsequent cases over a period of 4 or 5 years. It was also during this period, shortly after that particular case, that I joined the Miami Township Committee for Fair Practices. I don't recall exactly who introduced me to the organization, but I think it may have been Corky Cordell. But in any case, I joined this organization, which had previously integrated a number of businesses in town. And in '61, the state of Ohio adopted new legislation prohibiting discrimination in places of public accommodations. Prior to that, most of the anti-discriminatory legislation focused on employment, but this particular bit focused on places of public accommodation, included, just a variety of businesses. And after this legislation was adopted, the Miami Township Committee for Fair Practices decided that that would be a good sort of focal point for additional action at Gegner's Barbershop, which he still, continued to discriminate. After several discussions and preparation, the committee decided to initiate a test case, and there was some discussion as to who would be, who would serve as test case. And as it turned out, there was another person who had agreed to enter the barbershop and attempt to get a haircut. That person had as a witness. This is Francis Thompson, and Tom Holyoke, who was another Antioch person, was one of the witnesses. Later the same day that Francis Thompson entered the barbershop, Hardy Trollander and I did, Hardy being my witness. And of course I was refused a haircut. Hardy and I did not participate or get involved in any lengthy discussion with Gegner. We, after his refusal, we almost just sort of immediately just left the shop. And I promptly filed a complaint with the Ohio Civil Rights Commission, which was the enforcement arm of this new bit of public accommodations legislation. That started a variety of trials involving Gegner, and ended up 3 or 4 court cases, starting with the Common Pleas Court and ending with a petition filed with the Ohio Supreme Court. at that point, I probably should
Go ahead.
pass it on to Hardy to.
Finish up just a little bit, Paul.
Well, my time is up. In terms of the court cases, the Ohio Civil Rights Commission, which another Antioch connection. At that time, the director of the commission, the newly established commission, was a Frank Baldo, who had attended Antioch College. The commission held a quasi-judicial hearing here in the village, and as a result of that hearing, Gegner was found guilty of racial discrimination, and a cease and desist order was issued, which supposedly was to have cease and desist from his discrimination. And Gegner, of course, immediately filed a petition against this ordinance, against this order, and this was with the Common Pleas Court in Xenia. And the court appointed a Judge Young, to hear the case, the complaint that Gegner had filed. There was a hearing which involved just reviewing particular documents rather than any witnesses or anything of that nature. And in any case, this Judge Young, after a period of about a year, ruled that Gegner had been discriminated, that he had been discriminated against. That, in the sense that the legislation was really unconstitutional, and of course that decision resulted in a number of retaliatory actions, in the village. That was the starting point for several years, really, of picketing Gegner Barbershop. And of course, the Ohio Civil Rights Commission actually appealed the lower court decision. And it was at that point that I had contacted a legal firm in Cleveland that had been recommended to us, I think, by the Ohio Civil Rights Commission. And a John Duda was assigned our case. And this was a situation where Duda worked with us over a period of 2 or 3 years. And the Miami Township Committee of Fair Practices did reimburse him a couple $1,000s or so. But when you consider the time that he spent and the normal legal fees, it was really, a contribution on the part of this legal firm. But in any case, the decision of the Common Pleas Court was appealed to the Second District Appeals Court in Ohio. And after a period of about almost a year again, the Second Appeals Court overturned the lower court's ruling. And of course that resulted in a great deal of celebration. That was when the big local march occurred, involving about 500 or 600 people.